Welcome to the second installment of Protecting Employee Assets, the Life Cycle of the Employee Relationship, 2025, an ounce of prevention, policies, procedures, and proactivity. I'm Chuck, as he just said, I'm Chuck Krugel, the moderator, and slides 7 through 9 discusses of the PowerPoint will discuss the series itself and summarizes this particular episode. Slide 5 is our disclaimer that you can't go out and make important business decisions based on what you learned today in this webinar. We're not your advisors or attorneys. You're not our clients. This is just meant to give you general knowledge of the field and help you understand and work with your own advisors. And we'll go through the slides as we speak. We're not going to lecture off the slides, though, but we will refer to them from time to time, so you may want to follow them. Like all Financial Poise webinars, though, this is really a discussion amongst the panelists. And more about Financial Poise, by the way, is later on. I believe it's slide 41. Our panelists, as always, are Max Barrick of the Garfinkel Law Group, Helen Block of the Law Office of Helen Block, and Amit Bindra of the Prince Law Firm. You can find out more about us on slides 35 through 38. And if you're attending the live webinar, you could use the web portal to ask questions, or you could submit questions. We'll be monitoring the portal, by the way. Or you could submit questions after the webinar. Email it to info@financialpoise.com. Include your question and the name of the webinar also, and we'll do our best to get you an answer ASAP. Also, thanks to our sponsors, National Law Review on slide 3, and Max X Asset, a simpler and easier, better way to conduct online asset sales. They're on slide 4. Now, with all that out of the way, let's start with the actual presentation. Amit, let's start with handbooks. How essential are handbooks today? Does a business really need one, or can you get by with maybe just a few cobbled together policies or procedures, like in a pamphlet?
I'd recommend against the latter more than in favor of the former. The story I like about handbooks is kind of early in my career. I think I was working on one, so I was just trying to look at different handbooks, and Netflix's handbook I think came across my table somehow, and I thought it was really interesting and really well done because it was a great way for Netflix to explain its company culture. I think it was a good way for almost like recruitment and retainment for its business. So I think a lot of times we think of employee handbooks as a way to do a bunch of different things. But one thing is that it really does drive home a company culture if drafted well. Handbooks, I think, can do a couple other things that are pretty valuable. I think handbooks are helpful to help companies, just from a business standpoint, mitigate some potential legal liability. Because by having certain policies in place, it makes it harder for someone who's suing a company to seek certain types of damages. But can also allow for consistency and guidance for employees and then also for the company itself. So I'd recommend people use handbooks. I'd recommend, we'll talk about this further today too, that people kind of update them and look through them. But I don't think it's a good idea just to use some sort of pamphlet or something just thrown together.
Well, thanks. Helen, along these same lines, there's a ton of free resources on the internet. I mean, if you just Google employee handbooks and even to limit it, put a quotation marks, you get, over 500,000 responses. Some sort of canned document from the internet suffice, or like a pre-written document.
No, in a way, and I'll just in a way piggyback a little bit off Amit. In a way, it would be better to have a few cobbled together policies that are well written in lieu of a handbook than having a bad handbook. A bad handbook can do more damage to you than either having nothing at all or just having certain legally required policies to be in writing if your state requires them, such as a sexual harassment policy and a statement on equal employment opportunity. The reason why I say that is because the ones that you're going to find on the internet are very specific to certain types of businesses, and it might not apply to your business. There could be certain industry standards that might apply that are written into that handbook that you don't need that for your business, and it could hurt your business because it could give the impression that you were required to abide by certain types of policies when you might not have to abide by those policies. A good example is, let's say, FMLA. So for a smaller business, if you don't have at least 50 employees, you're not federally required to offer family medical leave to your employees. So if you're a business with less than 50 employees, why would you have in your handbook that you will provide family medical leave? If you put that in your handbook, then you better provide family medical leave. And maybe you're too small of an employer to be able to afford to provide family medical, leave. That's just one example. Now, certainly you can have policies in your handbook that um, that you don't necessarily by law have to provide. So for instance, in my FMLA example, you could be the kind of employer that maybe only has 10 employees, but you want to provide, 3 months of job protected leave to your employees. And that's perfectly acceptable. That's perfectly laudable, even if you aren't required to do it. So that's why it's important to make sure that your actual policies in your handbook match your working environment, match the benefits that you're legally required to provide. Don't provide benefits that you're not capable or able or want to provide. And that it's, consistent with, to borrow Amit's terminology, your corporate culture. It's really important that your handbook should match your corporate culture and also be tailored to the business. So for example, one of the provisions that you're going to find in any handbook, I mean, there are very few things you're going to find in every handbook, but one of the things you're going to find is a policy on discrimination, on equal employment opportunities. For, I would say, generally speaking, for the most part, these are staples. And so with that policy, it's going to be specific to your company. Who does the person go to? How do they report discrimination? Who do they make their complaint to? That's going to be very specific business to business. So you can't just glob something off the internet, make a bunch of copies and hand it out without reviewing it.
Thanks. And by the way, I've done some research on this myself, that if you put a policy in your handbook that you're otherwise not required to have, it's possible you could end up obligated to follow through on that. I mean,
Exactly.
It's obviously they're not, you could say that's not, you could disclaim it by saying it's not contract, but the reality of circumstances take precedent.
Because there are all these, policies that say this is not a contract of employment, and courts have decided that just because you have that language in there, that doesn't necessarily mean it doesn't turn into a contract. What it will turn on is the actual terminology from policy to policy in your handbook, not just having a blanket disclaimer.
Yeah.
Well, and also, and I have a case of this right now, and I know we haven't gotten to the leave of absence webinar yet, which I do encourage folks to tune into when it comes. But I have a case right now where a company wouldn't be FMLA covered for my client's purposes, but there's case law that says if you put FMLA leave and coverage into a policy document and give employees, do enough basically to give them the impression that you are an FMLA covered business and they are eligible and covered under that law, you can create a contractual FMLA requirement where one does not exist, which, as folks will learn down the road, if you then violate that law, there are some serious financial and legal consequences in the form of liquidated damages and attorney's fees on top of liability for firing or disciplining people you might not otherwise have. So really be careful, all joking aside about just grabbing something off the internet. If you're going to do that, you better darn well be careful. You actually look at what's in there, because you may not even realize what you're obligating yourself to.
Just to add something to what you said, Max, and I was actually on a case too where that came up, that exact issue came up, and fortunately it wasn't discovered by the plaintiff's attorney that FMLA was in the handbook, and I was able to get a count of FMLA discrimination dismissed. And it was a very scary sort of cat and mouse game.
Yeah, sometimes for my business clients, when they have their HR people cobble together certain things, you would not believe some of the things that I see. Like, for instance, there was one that passed my desk that had language in there about certain government contracting obligations, requirements. I can't even remember the exact terminology, but it was something that I think the government required in some state, that if you're going to contract with the government, you have to have X, Y, and Z in your policies. And so they must have found this off the internet somewhere, and it had absolutely nothing to even do with the kind of business that they that they were giving something that didn't even apply and I never even heard of before.
I see, and honestly, I see that probably in 50% of the handbooks that I review. I didn't talking about auditing a handbook, but even reviewing for litigation purposes, because for a lawsuit or something like that.
Yeah.
Thanks, guys. So Max, actually, let's stick with you. How often should a handbook be reviewed or updated?
So, and apologies if I sound a little wonky. My 4 and 2-year-old were really kind and gifted Daddy with several nondescript viruses. One of them may or may not be the flu. I managed to hold out for 6 to 8 weeks, but they eventually got me good. So sorry, I sound a little funny today. So that aside, I think we need to think about the answer to this question in terms of what's the bare minimum and what's a good practice. So like at the bare minimum, I think you at least need to annually be looking at it and saying, all right, what are we doing here? Has the law changed? But if you are only going to do once a year, then you need to really do a deep and holistic review. And that review needs to include not just looking over your handbook and saying, okay, how have we changed? Is our roster different? Is our values different? Are our processes changing? But also you need to look outside the 4 corners of that document and think about, well, what laws have changed in the last year? Or even before that, what laws are going to now take effect? And so the reason I would say that once a year is the minimum and probably not even enough is laws sometimes are phased in over time. And don't take effect all at once. So things like the Illinois Workplace Transparency Act, and that's a local Illinois law. I'm just using it as an example for national folks. I know it's not a national requirement. Required sexual harassment training to take place as of a date certain, as of another date certain, if memory serves. And this took effect 4 or 5 years ago. So some of the dates are starting to get fuzzy for me. But there was a requirement of reporting certain types of settlements or verdicts for sexual harassment, which in theory could lead to other audits by the Illinois state level version of the EEOC, the Department of Human Rights. In our state, there were these phased in Equal Pay Act requirements and pay transparency requirements that were passed 4 or 5 years ago, but didn't take effect until last year or this year, I can't specifically recall. And then even at the federal level, there was like the Corporate Transparency Act, which I understand has been the subject of injunctions and reversals of those injunctions. But that too was a law where it was passed at one point with the intention of not taking effect immediately, or even the Affordable Care Act was passed in 2010, but didn't really phase in for companies until later. So that's all to say, like, if you're only going to look once a year, then you need to be monitoring what's going to take effect later this year. And then separately, you need to have a robust HR or just compliance process that is constantly monitoring these things. Because if you're only going to do it once a year, they're going to have like addendums that you start circulating periodically if the law changes. Because think about like during COVID, we added a webinar that year for infectious diseases and what have you, in part because the law was changing at one point by the day. Yeah. Like they would Congress passes the FFCRA, Families First Coronavirus Relief Act. The Department of Labor hadn't promulgated any regulations yet. So we had to go back to the well and figure out, well, what the hell does all this mean? And all these different lawyers I knew were like doing these weekly webinars going, okay, here's what we thought the law was this week. Now it's changed. Now we got to do this. So forgive the rant or the monologue here, but it's to say you really need whatever you end up doing, whether it's once a year, once a month, once a quarter, you need to be concurrently up to speed on how the law is changing at the state, federal, and local level, because you need to know if your policies have to change. I'll give you one example. And this wasn't a like change every year, but it's just a like change someday at some point. I had a case against a trucking company, a logistics company, let's call it, and the company's handbook said, and this is in the state of Illinois where the wage laws are pretty strict and there are rules about paying a final paycheck. And the company's own paperwork said, if you don't give us 2 weeks notice, we reserve the right essentially to take from your paycheck to make up from the financial hardship you caused us with a lack of notice. Well, in Illinois, that would violate the Illinois Wage Payment and Collection Act on its face. So in a settlement call with the other side near the end of the case, and I got along with my opponent, I said, okay, off the record, I got to ask, have you talked to them about the fact that their handbook has a flat violation of the law written into it? Like, do they realize this? He goes, yeah, we're doing a holistic review of everything as soon as this is over with, because there are about 4 or 5 things that may have been kosher when this person's father started the company. but now in 2020, whatever, they are per se legal violations. So whatever you end up deciding, whether it's once a year, quarterly, or just as needed, you need to make sure you are concurrently monitoring changes in the law.
By the way, who knows the answer to this one? Corporate Transparency Act, in effect right now or not?
It is in effect right now.
Yeah. Yes.
But someone has until March 21st, 2025 to report.
I think that was as of last week, right? It just went
Beneficial.
back.
Yeah, it just got changed.
Yeah,
Well,
off the
and
subject.
to add to what Max said too, in 2025, I think most companies aren't just going to be in one state, and they're definitely not going to just be in one county. And so what adds to a level of complication here is there are different laws based on city, counties, and state. So in Chicago, you may have different pay laws than you would, and in Cook County than you would maybe in Naperville or the rest of the state. And that's true across the board. So, for example, the California overtime rules are different than the federal rules and the state rules in other locations. So it's also important just to update it for those reasons, because the law at every level is changing rapidly. And so what may have been true 6 months ago may no longer be true. And so there's other problems a company could face because of that.
Yeah, like New York, for instance, I think, because it sounds very unique. And I know Illinois is rather robust, but this is very different than Illinois, and I haven't seen it anywhere else. Maybe, Ahmed, I know you follow out this stuff. Maybe you have seen it in other places. But New York, I think, is going to be instituting a law about pregnancy and fertility, and that an individual should have a separate bank of 20 hours separate from their sick leave bank, 20 hours to use for, let's say, fertility, pregnancy, et cetera, type of treatment. And I haven't heard that in other jurisdictions. And that seems like a new one even for me, which underscores the importance of updating your policies, procedures, looking at it with changes to local law, because oftentimes local law changes far more rapidly than federal law.
Yep. Well, and that's a good point of just leave policies. The sick leave policies are different even within the same state. So it's really important to stay up to date on that, because if you're a company that historically was using one PTO vacation policy, that may no longer be a good way to do it for a whole host of reasons. So you might be paying out more PTO than you intended because of how you wrote your policy.
Well, and to the California example, I feel like every national company I've ever had a case with where I've gotten a hold of the company handbook, if it's a big company and they're well organized and well run, the amount of disclaimers at the end of the handbook that have asterisks saying, except for in the case of California, where this law is in effect, or, and Amit and Helen's favorite, there'll be restrictive covenants, and they'll say, except for California, where X, Y, and Z are not even enforceable anymore. Like, it just, I think maybe more important than how often you're actually updating it is just how you monitor the laws themselves, and then what steps you take. It may be the case where you don't have to change employee handbook policies, but you just need to change certain practices. But I think it's just a case of like the title of the presentations of an ounce of prevention's worth a pound of cure, like just keeping in mind that having a red line on the books for compliance is not a bad thing, because it keeps the red lines for legal expenses, litigation costs, and attorney's fees way, 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 way smaller. And you usually have a happier workforce if they at least know where the rules are.
Excellent point.
A great example of this is the Biometric Privacy Act in Illinois, because it has very technical requirements as to what companies have to do if they want to capture an employee's biometrics, and having a policy is part of that. And so a policy is not very expensive to create, but that lawsuit and liability is super expensive. And so just merely getting a handbook online or from maybe your payroll provider is not the best practice, because you want to make sure everything's captured in there, because if that policy potentially is missing, along with other things, that could be a huge 7-figure hit.
Well, thanks. Great points, everybody. Amit, let's stick with you. I see a lot of handbooks and policies that use like legalese and jargon. Especially when it comes to Helen brought this up about the contractual relationship aspect of handbooks, and then also like at-will employment language. How much does that really help, all the legalese and jargon?
I think generally it's good to avoid jargon and legalese, but it is also good to explain things to folks in just plain English.
Yeah.
One of my favorite examples of this is a good friend of mine wrote a contract for a client, and the client called him up, a corporate client. The client said, "Look, I don't think this is legally enforceable because this is too simple. Like, I can understand this, so there's no way this could hold up in court." And the response is like, that's exactly how it should be. If everyone in the company can understand what your handbook or your policies are, then you've done a good job of communicating it. So that's not to say that you shouldn't have language that you need. It's just, how do you draft it? And I think you want to be thoughtful about drafting it in a way that's accessible to your audience and easy to understand. And that's true, I think, of a good handbook, but it's probably true of contracts and a bunch of other things where we don't need to over lawyer the language. We should be writing it, I think, in a simpler way. With the goal to protect the company.
So I get the impression that a lot of these documents, and I see this in contracts, legal contracts too, not just policies, that they're written that they're not written for lawyers and for people, but they're written by lawyers in order to make it look like they look like it's been, written by lawyers.
Exactly. And a lot of times the lawyers who write those types of agreements or documents aren't the ones who are in court trying to enforce them.
Yeah.
And so I think when you do a little bit of both, you get a better sense of, oh, if we word it this way, this makes no sense. And so no one's going to understand what's going on, or it is going to be ambiguous and confusing. And that's not in anyone's best interest. That's just going to make more problems for everyone and create more headaches, which in turn leads to more costs, more potential liability, more exposure. So I'm a big fan of just a simplification of just legal contracts.
Thanks. Helen, what are the hot topics right now, like in handbooks and policies that you're seeing? What's coming across your desk the most?
So there are certain things that really definitely need to be in handbooks, such as on sexual harassment, who to report sexual harassment to, because there are different jurisdictions that have requirements that you have to have certain policies in writing. One of them being sexual harassment policies. Another thing that's important to put in your handbook, and this is going to vary from state to state, is what is the definition of the protected class? What is a protected class? Meaning, is it just what federal law puts in, such as race, religion, national origin, gender? Or are there other things that are protected classes according to your state laws, such as arrest records? Like, you can't discriminate against someone based on the fact that they have been arrested. So these are some nuances that you're going to want to think about that are, hot topics that you're going to want to address. Another big thing is leave, really kind of nuts and bolts things. Like, if someone wants to take a day off, or if someone's going to come late to work, what are the rules for that? How do you follow it? Who do you need to tell? How do you request time off from work? These are things that should be very specific in your handbook so that everyone knows what the rules are. And so it can be uniform. And if folks aren't following those rules, then the employer can discipline the employee for not following the rules, because everyone knows what the rules are. And so in order to try to negate as much as possible exposure to liability, it's important to have those policies very clear so people know what the rules are, so they can be evenly complied with and evenly, disciplined, and everyone treated very similarly to the best of someone's ability. So I would say things that are very important are your leave policies, who to report complaints to, sexual harassment, discrimination. Those are important. Expense reimbursement, anything that has to do with wages, which includes incurring expenses on behalf of the business, how to get reimbursed, who to submit your receipts to. Really nuts and bolts day-to-day stuff of who to go to for what questions and where and what types of questions and what types of issues is what should go in the handbook. Now, with that said, a handbook shouldn't be so restrictive that an employer loses flexibility, because then sometimes the handbook can constrain the individual. And let me give you a practical example of that. Different people have different things that are going on in their life. And so sometimes it's easier when things aren't written into a handbook to have that flexibility. So for instance, if let's say someone has a religion that has certain religious requirements or needs, you have to have the flexibility to be able to accommodate someone for those religious needs or religious requirements, or let's say, disability. So you don't want to have language in your handbook that makes it impossible to have the flexibility to give someone a reasonable accommodation, let's say for their religion or for their disability. For example, let's say that I had a client one time that I really tried to talk the client out of putting this in the handbook, but they still wanted it. They own their own building. Okay. So this client of mine took such pride in this building, but the client didn't realize that your employees who you're paying to do a job are not going to take the same pride as you. So this client really wanted me to put in the handbook about fixing things up in the workplace. Like if you see something like a chip of paint, like take a paintbrush and paint the walls. I mean, I kid you not, the extent of this. And I'm thinking to myself, this guy is opening himself up to a workers' compensation, injury. Some folks are going to be interested in taking out the garbage. Some aren't. Are you going to then discipline people for not taking out the garbage? I mean, that's how specific this person wanted it. And I really tried to talk the person out of it because I really don't think it was in their best interest to put something like that in the handbook. If you want to have like a little, spiel with your folks, clean up, do this, that. If they do it, fine, not. But now that you put it in your handbook, then you're going to have to treat people the same if they don't do it. And then what? You're going to start disciplining people because they didn't, paint the walls and take out the garbage one time. So those are some of the things that you have to keep in mind, that you don't want to like literally regulate every single aspect of the day-to-day of the job, because you still need some kind of flexibility.
That's an interesting point. I was just picturing like somebody removing chip paint, like wet, chip paint, and inhaling them and all that. So.
Right. If something's broken, fix it. But then again, I had another client who had something, he was like kind of a do-gooder, and a lot of the employees were low income. And we put together a whole policy on providing interest-free loans. And that took some time. And so that's interesting, which that goes back to, again, Amit's corporate culture comment. The handbook should be specific to your business. And if there is something that's specific to your company, put it in there. And so in that situation, we spent a lot of time on this, how is this whole loan situation going to work? And I thought that was a nice idea. I didn't try to talk the individual out of that one.
That's pretty cool. Max, some employers, they like to include like open door complaint policies in their handbooks. I've also heard from the other side that some employers say by having like an open door policy or allowing anybody, access to employees, or vice versa, allowing all employees access to anybody is just inviting trouble. What do you think about these types of policies and why?
I mean, look, I sympathize with employers because I've handled cases before where, even aside from my client, it is very clear that it's sort of a backbiting, drama-filled, litigious workforce where everybody's kind of sniping at each other and complaining about disrespect and bullying, none of which are illegal. They're just, I guess, not ideal. So I get that it's like you don't want to be policing the playground. You want to be running a business and dealing with big picture problems or specific and acute issues, and not Jimmy stole my pencil and was late by 17 seconds today. So I certainly get that. That said, a well-crafted policy of that nature that doesn't just say, hey, it's an open door, we want to hear all your complaints, but gives some guidance on what's important and what's not, and tells them where to go, and gives structured processes for raising concerns, and tells them, look, we don't want to police that Jimmy sneezed too close to you, but if you're telling me Jimmy is ill and spreading an infectious disease around, and creating a safety hazard, like, you need to know that information. There are OSHA consequences to that. So I think you want to consider some way, clearly delineated and well-explained policy for complaints, so that there is no confusion about where employees are supposed to go with that information. The legal reason for that, at least in part, is think about a whistleblowing or discrimination matter where maybe you're the owner or the general counsel and you're not aware of everything that's going on day to day and on the ground, but there's something serious going on. You have a supervisor committing sexual harassment or some form of illegal behavior. You obviously want, putting your fingers in your ears and just sort of hoping these things work themselves out. While a fun answer on the SAT prep test to not select like is not a good practice for avoiding legal liability. And to the contrary, at least in the discrimination venue, you're opening yourself up to serious consequences if there isn't a meaningful complaint avenue available, let alone a process for remediating or investigating these problems. So whether you call it open door or you just have a well-structured reporting mechanism, I don't really care how big a business you are. You got to have some avenue for people to raise concerns. And it can't be like, for example, what Wells Fargo was accused of doing when they got into all that trouble for coercing fraudulent
loans and
bank
accounts.
Well, one of the allegations against them was that they did have an employee whistleblower hotline, but it ended up getting used such that when people would report that they thought this was a problem or it was dangerous for the company or illegal or unethical, they were getting rooted out and fired. So like you need to be really cautious about it. And I realize some entities have more aggressive stances with respect to their workforce for one reason or another. But at some point, I think it's just understood it's the cost of doing business. Things are going to happen. If you exist long enough and you're big enough, it's the cost of doing business, whether it's meritorious or you just made a bad hire or somebody kind of hoodwinked you and is really a bad fit. You need a way to find that out. So might it lead to you dealing with a few annoying and frivolous complaints that are beneath your pay grade? Absolutely. Very likely even. But is that worth the cost of prevention here? Yeah, I think it is.
I think Wells Fargo licensed their hotline to the Department of Government Efficiency.
Apparently, it certainly seems that way.
I mean, as a routine part of my practice, I do draft handbooks. And so, talk and answer to your question, I do recommend putting a policy in there, like an open door policy, where if you have a complaint or you want to address something, please bring that to management's attention, along with an anti-retaliation policy that you will not be retaliated against for bringing forth a good faith complaint or concern. And it is better, even if you have some people who are really persnickety and feel like they have to report every little thing to you about what happens in the workplace, you soon figure out who those people are, and you then kind of take it with a grain of salt. With that said, it still is better to know every little thing going on in your business and not put your head in your sand, so that you can try to correct problems before they blow up and turn into massive liability, to be able to nip things in the bud.
Well, better hear about it from your employees than a government regulatory agency or their employees' attorney. So,
right, sure,
yeah, exactly. There's a huge ROI in having these policies. The ROI is going to be twofold. Yeah, one is ideally that means you have less legal claims being actually filed against you because you're getting ahead of it. And two, if there is a claim being filed, you can say, look, we should do this seriously. We have policies in place. We investigate them. There shouldn't be punitive damages here, or et cetera, or whatnot. And a third benefit is I do think it increases overall business productivity. If you do have a bad apple amongst your staff, it's better big picture to find it than to let it linger and then harm overall productivity of the business. So there are, I think, there's a good business sense to doing it this way.
Well, and two more points to that effect. Number one, if you do have a well-documented, well-understood, and well-used complaint mechanism or open door policy, if there's a lack of documentation, and I've seen this in cases before where you have an employee who's willing to complain about certain things, but when it comes to harassment or discrimination or wage or other whistleblower type issues, and there's no record of it, it's a lot harder for that person to come back and say, well, I complained, there was a mechanism here. It's like, yeah, you complained 10 times last year, and all 10 of them were about, the water temperature in the bathroom sink, but there's no record of you ever saying, and oh, by the way, Billy is, sending racist or sexist memes around the office. There's no documentation of that. And you clearly knew how to document complaints when you wanted to. So that can protect you to that angle. But the other thing is, think about the flip side and the positive angle. You want employees to know and feel like there is a mechanism and way for them to help and have ownership of the business. And I don't mean ownership like financially. I mean, come to you with good ideas. I think about, and it's a silly example, but I used to watch the show The Office. And one of the storylines at some point is the company, Dunder Mifflin, gets bought by some company, tech company owned by Kathy Bates. And like one of the things she does in one of the episodes is she holds an office-wide meeting where she says, I want to hear from people. And one of the employees who's been relegated to the warehouse his whole career says, you're doing things inefficiently. Paper and printers don't ship the same way. If we change our processes, it looks different on paper, but in practice, you're going to save money because you're going to save space in your trucks and all of it. Now, it's like a silly example, but I think it speaks to the culture and what you put in your handbook and how you communicate with folks. If you convey a message that we want to hear from you, good and bad, people are more likely to have an incentive and skin in the game and participate positively, and also tell you when you can get better or somebody's hurting your company.
When to add one more piece to that, if Billy is sending around sexist memes, well, when you have to separate Billy, you have a good argument as to why, and there's going to be no claim to be filed. So not only have you weeded out someone who's, hurting the business, you've also now prevented a legal claim from being filed or having merit because you've documented, or you at least have documentation to confirm that the separation had nothing to do with like a violation of the law. It was the person was sending sexist memes.
A great discussion, everybody. Thanks for those points. Amit, one of the things I've seen with handbooks, I've seen this countless times, is handbooks that are employment policies addressing 1099 independent contractors. I mean, how much should an employer address 1099 related issues in an employment handbook or policies? And also, I mean, do they need to define like the classifications in their policies?
So, and this is, I think, it's a great question, and I think it's an important question because, to your point, this happens a lot. There are more and more, I think, state laws that are applying state discrimination and human rights act applications to contractors or folks who may be on site for the company. So there is a thought of, you may want to employ that handbook policy to contractors as well. And I think you have to be thoughtful about that depending on your jurisdiction. But the handbook itself is not going to be a great place to determine whether or not someone is a contractor or an employee. Like, you can't just dictate that or fiat it. That's going to be a multi-factor test. So that type of question is going to involve talking to competent employment counsel to determine whether or not someone is a contractor or if they are employees. And the same thing with overtime. Just because you say someone's not eligible for overtime doesn't mean it's necessarily true. So I think companies should be cautious about that. At the same time, I think you can have some policies in place for the folks that are eligible for overtime. Do they have to seek it? How do they get it? Those types of things I think are fine to put in a handbook to say, you need to request it from your manager. You have to let us know, those types of things. But the handbook won't be the be all end all as to whether or not someone is a contractor or not, or whether or not someone should get overtime or not.
So great, thanks. Helen, one of the fundamental aspects of handbooks and policies are progressive discipline. What does this policy mean, and does it really help to have one? And if you do have one, how dogmatically do you follow it or adhere to it?
That's a really good question. And dogmatic, I think, is the key term that you've used. And I think it also partly depends on the size of the employer too. As a general principle, you don't want to necessarily be so dogmatic, because the default to the overwhelming majority of employees in places of employment is employment at will, meaning I can terminate you for any reason, no reason at all. You can quit. You could decide, hey, this is not for me, and not come back after lunch. That's what at will employment is. If you have a progressive discipline policy, and let me explain what most people think about progressive discipline is that it's some kind of a structure that the more severe the infraction, the more not even just more severe the infraction, depending on the number of infractions, the frequency,
Quantity,
the severity. There are different levels of discipline. And when you think of progressive, you think of you have to follow each level of discipline. So if you have a policy that says that you have to follow all these levels of discipline, then you have basically gutted out your employment at will status, because then you're basically telling your employees that they can't just be terminated willy-nilly at will without the employer first following this discipline type level of policy. So if you want to keep your at-will status, be very, very careful how you use that terminology, progressive discipline. And if you do want to keep that at-will status, I would not make it a requirement that you follow a progressive discipline policy. When I draft policies that have different levels of discipline in it, that have different, you could tell, or severity, as opposed, a written warning as opposed to a performance improvement plan or a coaching, one certainly sounds harsher than the other. I always make sure to have language in the handbook that this does not change the at-will nature of the employment, that the employer does not have to follow any step. It could be any of these kinds of disciplinary types of procedures at the discretion of the employer. You can use a step, you can avoid a step, it can be in some type of a format, but you don't have to do it at all. You can just, terminate an employee. It doesn't, nothing violates or nothing alters the at-will nature of the employment. And that part is very, very important. So I would say if you want to maintain at will, you can have different types of discipline which seem progressive as a progressive nature, but it shouldn't be mandated that it has to be followed in any sort of progressive step. So for instance, you can have, let's say, someone can be coached. Here's what coaching is. Someone might get a written warning. Here's what a written warning is. Maybe we'll put you on a performance improvement plan. Maybe you'll be suspended. These are the different kinds of discipline that the employer might choose to use in the workplace. Doesn't have to. And that's generally what I recommend. And that's generally how I draft these policies.
Oh, thanks, Helen. Max, this is a fun one. Labor organizing has been on an upswing over the last few years, 4 or 5 years. What about having in a handbook some sort of policy about, a prohibition against organized activities or organized labor activities? Can a company have this in the policy or handbook, or what about even like having a no strike or no slowdown clause in their policies?
I mean, I wouldn't recommend it. No, I mean, with the caveat that in the last few weeks, some wild changes to the Department of Labor and its posture.
NLRB too.
Excuse me. Yes, the National Labor Relations Board is what I meant. The Sudafed is clearly kicking in. To the NLRB, its posture, its right to exist, and what have you. As a general matter, you can't prohibit concerted activity of employees. You can't stop them from getting together and talking about working conditions, wages, legitimate concerns about the job. Not I hate my boss and screw this guy, but you just don't want to do that. Obviously, most employers prefer not to bargain with unions. They would rather deal with employees one-on-one. I've heard management lawyers say we prefer that because it gives us more freedom to deal one-on-one with employees. It allows us to make special exceptions and treat people uniquely. Whereas if there's a collective bargaining unit in place, we have to abide by that and we have less flexibility. Plus, it can create a stressor for the business. I'm not here to litigate the morality of that or say whether one is better than the other. I think what I would say instead is that you want to think about why people are making that commentary, right? Like my own interaction with different industries as a plaintiff's lawyer sort of informs this. I have found, for example, because we found ourselves litigating a bit at my firm in the cannabis industry, that particular workforce seems to be a little bit more militant and motivated to go the organized labor route. And in ways that I have not in other industries, I've talked to a lot of potential clients who seem to almost be like warriors in that front, where like they are looking for that fight. I don't think that's common. There's just something odd about that industry that I found is attracting that. I think what I've seen that is allowed is employers who have handbooks that say, look, we really like our workplace here. We feel we treat employees well. We think if a union is put in place, that'll put a wedge between us and you and prohibit us from dealing with you guys directly. if you have concerns or you're going that route, we really, I mean, I think this goes back to the open door policy and some of the other things we're talking about, like creating not just an impression, but a reality where employees feel like their concerns and issues are valued, their feedback is valued, they are valued, and that there's no need for organized labor there will do more, I think, to head that off than union busting that, setting aside whatever's going to happen now, in theory, could get your organization into trouble with the National Labor Relations Board.
Chuck, I have a question for you because you used a term that I'm not familiar with. And if I'm not familiar with it, our listeners might not be familiar with it. What do you mean by slowdowns?
Like when employees basically, there's a couple different ways they could do this. They could start following every rule in procedures or even in the handbook, so to speak, and you follow every rule, just things slow down, or they intentionally slow down their rate of work. So, I've seen it done both ways.
Where it's like, yeah, they're not, see, I watched a show where that happened one time where it's like, yeah, they're still doing the job. They're just doing it at 1/10 the speed.
Yeah, exactly.
It's 30 seconds to walk across the building, but they're shuffling one step a minute or something. It's just not going anywhere.
Or they know that if they follow every procedure, down to, the minute point, whatever, that their work will slow down.
Yeah.
So that's where it comes up. By the way, here's one I'll throw out to you guys too. What about if you put in your handbook a statement like, a union will jeopardize our business and may put us out of business? Or adding on, may cost you your job.
I've seen that before. And my understanding, and I am not a big L labor lawyer, was that the employers are not supposed to put their thumb on the scale, at least when there's an active union drive or vote.
That's a good point.
Because I remember there being some fights over that when like congressmen were weighing in Tennessee when there was a Volkswagen plant that was voting on whether to unionize or not.
Yeah, I think that implicates the NLRA. Now, maybe you can get away with it depending on what's going on with the National Labor Relations Board in a given administration. But I just think that's not a great idea. I would not advise a client to do that. Because when it's in writing, it's much easier for some employee to, at the very least, file a charge with the National Labor Relations Board, and then they are going to look into it as to whether or not that implicates the NLRA, and you don't know what's going to happen from there.
So the former statement, like in terms of jeopardizes our business, might be more, you may have more wiggle room there. And depending on how you word it, I think the latter statement, jeopardizes your job, is probably not going to get past the is probably just not going to be enforceable, or
Yep.
won't get past NLRB scrutiny.
And at a minimum, I think either statement is going to lead to some sort of investigation by the NLRB.
Yeah, I mean, and that, yeah.
So then becomes a question of like, what's the upside of doing that?
Is the benefit worth the cost?
Yeah, exactly.
Well, thanks. Amit, let's stick with you. This is always a fun one too. Can you put in a handbook or a policy something like, by signing this, or by accepting this handbook, you agree to waive, or accepting employment with us, you waive your claim to anything like any sort of job action, harassment, discrimination, or something along those lines?
I mean, the short answer is no. It's not going to be. I mean, you can include it, but it's not enforceable. The longer answer is it's not enforceable. Because you're not able to generally waive future rights. So even if you did sign such a release on day one of your employment, something happens day two, that release likely would not be enforceable anyways. And separate from that, states have different rules on what you need for an enforceable release, as does federal law. So if you're under the age of 40, the document may need different types of language. If you're in California, the release needs to be different. And on top of that, and we've talked about this already, whether or not the handbook is a contract could be an issue. So it's just not a smart way to do it, because practically it wouldn't really help. But then also, legally, it's just not going to be enforceable. So if you want an employee to sign a release, you should have them sign a contract. And typically, if you sign a release and then continue working for the company, you have to sign another release on your last day of employment, because the original release won't cover the gap.
Also, there's a lot of states or municipalities require that any time an individual action is taken that could be adverse or adversely, especially if it adversely affects your paycheck, like a
Yep.
deduction or garnishment, it has to be done on each individual, during each individual instance. It can't just be a blanket waiver.
And that's a good point. There are certain non-waivable rights. So rights to wages typically aren't waivable anyway. So it wouldn't help you with stuff like that. And I'd even go a step further. If you want, for example, a non-compete or confidentiality provision, I think a company is better off having that as a standalone document with the right language, reviewed by the niche attorneys who do that type of work, because you need specific obligations in those contracts. And those contracts are different state by state. So in Illinois, you have different requirements for a non-compete than you do in Indiana or Texas. And you have different requirements even for a release agreement, even for folks under the age of 40. So it's just not a good way to approach it.
Yeah, anything that abridges the individual's employment agreement, whatever, their relationship with their employer has to be on a case-by-case basis, a lot of times. So
Exactly.
thanks. Helen, what about translating policies into other languages, like non-English languages? Is that a good idea? Or if an employer does that, are they just opening themselves up to more exposure or liability?
No, the opposite. So if you have a workforce that is comprised significantly of a certain language speaking population, then it would be a good idea to translate it, because the whole point, not the whole point, but one of the points of having a handbook or a policy is so people know what the rules are. And if people can't understand the rules, what's the point of having it? Because you're not gonna be able to say to that employee, hey, I gave you a handbook, you should know you shouldn't do this. It's a violation of the rules, when you're on notice that they cannot understand that handbook. And there are some policies mandated by law that have to be in a specific language. So for instance, there are some, let's say, restaurants in certain jurisdictions that, if you're a restaurant and it's kind of implicit that you're going to have employees who are Spanish speaking, then some of those policies must be in Spanish. And so there are jurisdictions that already do have laws about certain policies needing to be in another language. So again, I come back to that. If you do have a place of employment that has a lot of employees who speak a different language, and they don't, especially if they don't speak English, it's not that their English isn't, the best, but they don't speak English, then I would highly recommend having a handbook translated into the language of the work staff.
What
Well,
about
it goes back to, sorry.
I'm sorry, go on, Hamid.
Well, it goes back to the question too, what's the purpose of the handbook? And really it is to set good expectations and guidelines and to work on company culture. So if your workforce is a non-native English speaking workforce, but they speak another language, it benefits the company. It's the same conversation we've been kind of having. It's the same reason why you don't want to use legalese in your handbook. It's the same concept of you want folks to understand it so that way they understand what they can do in terms of reporting issues, what their obligations are, their duties, and they understand the corporate culture.
So so one of the things that's changing on a day-by-day basis is DEI stuff. So a lot of companies say we like to be inclusive and all inviting and all that, but if their handbook is just in one language, or if it's not accessible to deaf or blind people, then obviously that's problematic, and also it seems hypocritical if they're trying to be inclusive.
Well, and if you have people who request ADA accommodations,
exactly,
you can't discriminate. If you have folks who are hearing or visually impaired or have learning disabilities or what have you, and need you to make it accessible in another way, you run the risk of a claim if you don't. So, just something to keep in mind.
Not just run the risk of claim, but run the risk of being found guilty too.
Also, yes.
I think your chances of guilt are largely increased if you can't show, if you can't prove accessibility or translatability or something along those lines.
Well, and with the leave and disability type claims, and it's the same with some of the conviction and arrest, I think it's conviction history, but sometimes it's not really about what was your intention or whether you meant to discriminate. It's really going to be a case of, did you check the box of what you need to do? to meet the minimum thresholds under the law. So I think, if I had a takeaway message, not as the management side, is that, this phrase, I'll say it again, the ounce of prevention being worth a pound of cure really does matter, because having robust policies that are consistent, understood, easily accessible to people, and updated regularly is more likely to keep a happy, understanding workforce who gets what is happening and why, and is less likely to start acting out or feeling litigious or like the company's out to get them.
Well, here's a fun one. I mean, does intent, I mean, Max, you mentioned like intention. I mean, does that matter relative to the handbook? Like if you're in violation of a law or something like that?
Well, not specifically. And I mean, we could talk about any of the laws that have come up today.
Yeah.
The Illinois Biometric Privacy Information Privacy Act is a local one, but it's an example. If you collect somebody's biometric identifiers and you don't mean to break the law, that's not part of the analysis. It might mean you're compliant on other topics, but if anything, that might actually exacerbate your exposure, that you're reckless or negligent or willful in the violation, that you could, take steps to protect PII and other sensitive data, but you didn't bother to deal with this issue. That can amp up the exposure. And I mean, the wage violations I talked about earlier, maybe you mean to pay everybody every dollar and follow the law, and your heart is not hard, but if you're breaking the law, sometimes it doesn't really matter why you're doing it.
Yeah. All right. Let's stick with you, Max. Should businesses train or do orientations with their employees on their handbooks? What kind of training you think is best, if there is such a thing as a best training or best practice? Who to train, how often?
I have a silly answer that I'll avoid because we're short on time, but it involves a mime and acting things out. I think, look, if you want people to follow your policies and procedures, then you darn well better tell them what they are and what your expectation is. I think good companies that care about this sort of thing do regular training sessions when they want people to do it. I think work from home, remote is all very good, and there are good reasons often to use that. At the same time, if it is possible, at least temporarily at the beginning, to get people in for an in-person training, I think there is no substitute for hands-on help and ensuring people are paying attention. I've seen, for example, doctors' contracts where they say you can have a modified schedule, certain activities may be remote. However, for the first X weeks of your employment, we expect you to be on premises even more hours than you normally would be, so we can get you up to speed, trained, and knowing how we do things the right way. So the long answer to your short question is yes, always train people, do it early and often. Renew the training every year, especially if there are changes or people are getting lax on certain practices. And whenever possible, at least do it in person. I think written training is very weak in these settings, because the amount of times I've heard employees say, yeah, well, I got that, but I never read it. I realize that may not be a defense in court, but if you actually want them to do something, then talk to them about it.
Oh, great. Any other points? We're at the top of the hour. All right. If there's nothing else, we thank everybody for attending. We're going to be back for number 3 in the series, Show Them the Money, Wage and Hour Compliance. That's on March 27th. I believe that's a Thursday, also at 2 p.m. Central Standard Time. So hopefully you could all come back then. I know all the panelists, Max, Ahmed, and Helen will be back. And thank you all for your participation in this. Take care, everybody, and see you next month.